and welcome everybody to another episode of Transform Your Practice, Transform Your Life. My name is Kristina Schneider, and I'm a practice success coach here at The Ultimate Estate Planner. And I am super stoked and excited to do today's episode because this episode, like some of my others, is likely to ruffle some estate planning attorney feathers. And I came up with this episode topic from our recent event down in Carlsbad. There was some tense moments with just differences of opinion, and I thought it was a podcast-worthy topic to discuss. So today's topic is entitled Protecting Your Time, Protecting Your Practice, Avoiding Estate Planning's Biggest Time and Liability Traps. And I'm basing a number of these practices that we've seen in recent times come forward by many attorneys, and I'm just going to share opinions. And keep in mind that a lot of these opinions are based on a almost 45-year law practice that is still open and thriving today. That's had very minimal amount of probate cases, litigation matters, and other kinds of E&O claims and things like that. So that being said, let's jump right into it. I will say that practice number one that we're seeing is this movement towards having non-attorney salespeople kind of being a part of the intake process. A number of firms have very highly skilled and trained intake specialists in their practice. And the idea behind it is that while I understand naturally for a lot of lawyers, the idea of selling and being salesy and even quoting their fees and other things like that, it makes them uncomfortable. It's not something that's natural to them. I do think that they are doing themselves a disservice in a lot of ways. For one, I will tell you that no one's going to have more authority than the attorney, him or herself, in front of a prospective client. That's number one out the gate. The other thing that I've seen in so many firms is that the firm becomes so highly dependent on these highly skilled specialists that when those people walk, for whatever reason, they leave the firm just crashes. It's not a sustainable model because the law firm doesn't have any backup to kind of fulfill that need. There's no skill set there, there's no training, and the lawyer may not be able to do it or have the capacity to do it. So that's another big kind of downfall that I see with it. And then the other thing that I've seen, it just depends on your practice and kind of what you have that legal intake specialist do. A lot of attorneys will say they're just doing intake, they're just taking down client information. And what I'm seeing is that a lot of intake non-attorney salespeople are also, unfortunately, kind of crossing that gray line of giving legal advice. I'll give you an example. The example that pops to my mind is a prospective client in that meeting basically saying, "Can't I just get a will?" Well, while the non-attorney salesperson might know that answer and might know how the attorney would answer and maybe would be interested in pushing for that client to get a trust-based plan, based on the attorney's practice and maybe the state that they're in, the size of the estate and things like that. My question is, should a non-attorney be able to answer that type of question? At what point are you crossing that line of providing legal advice, of making legal recommendations to the client? And so I think that a lot of lawyers that are moving towards this model are unfortunately, it's questionable practice. And I just think that issue number two is a big one. And there are definitely other systems around allowing that attorney to maximize his or her time, to be that authority figure, to not have to rely on these highly skilled, specialized intake specialists that they fear ever walking away from their firm. And frankly, they will avoid any kind of potential unauthorized practice of law. So that out the gate is one issue. Another big one I'm not going to spend too much time on because I have an entire podcast and articles and other things that go with it about sending drafts to clients. I understand why people do it. I have a lot of lawyers that will tell me, I don't care if they even read the document. I'm like, really? They just want to check off the box that they said to the client to review their document. And I just think it's unfair for attorneys to rely on consumers and lay people to be able to understand what the heck it is that they're reading. I have said this before, but I have been in the estate planning industry for over 20 years now, and I would have trouble reading a trust-based plan with the legalese. My eyes would definitely cross. So I'm not a big fan of sending drafts. I think it's the death knell of efficiency. I think it creates a lot of unnecessary questions and delays and questioning of the plan and this and that. And I just don't think it's in the best interest of the clients. So that's number two. Number three is draft review meetings. I have a number of attorneys that like to do draft review meetings. I certainly understand. I can see the pros of doing that. I have a lot of lawyers that say it certainly saves them from same day of signing changes when the clients have massive changes to their plan for any reason or things like that. The biggest issue I see around these meetings are twofold. A lot of people do these review meetings virtually. So one question I have for you is, in a virtual meeting, can you verify without a shadow of a doubt that there's no other people in the room with them, that there was confidential conversations that happened, that if they're looking down at notes to changes that they wish to make, that those notes are in their own handwriting and not being slipped to them by an unscrupulous beneficiary? Can they even test for incapacity and the mental competence of the client? And Phil Cavish's position on that is you can't. You cannot do it the same way that you can in person, where you can pick up other signals and body language and other things about the client in that way. And so that's one issue. But another major issue that we see is that the timing of when the documents get signed after these document reviews are typically not same day or immediate. They are typically maybe 1 or 2 days later, in some cases 1 or 2 weeks later. And this is where our position really is, can you, without a shadow of a doubt, tell a court of law that the client knew exactly what it was that they were signing at the point of executing and signing those documents? You can say, I reviewed the document with them. Yes, you check that box off, but at the point of actually signing the document, you did not review the document with them. You reviewed it 2 weeks before, and the question is, does the client still remember and understand what they signed 2 weeks later? And, frankly, a lot of attorneys in the estate planning industry, as you know, you're dealing with elderly clients, you're dealing with people who potentially have very lucid moments one day and then very, unstable status of their capacity another day. And so, again, just another area where we spot and identify potential liability traps for estate planning lawyers to consider. Our methodology is reviewing the document with the client at the point of execution. And that meeting is done 100% for us by a lawyer in our firm. So that brings me to the next point, which is having non-attorneys 100% without the presence of a lawyer at any point conduct the execution meeting or signing meeting with the client. Again, a lot of attorneys do this because they do that draft review before, or they have some instruction to their paralegal about just indicating that they cannot answer any questions and da da da. And the question I have, or the issue that we have with it, is twofold. Again, without an attorney present at the point of executing the document, you lack this, like there was a lawyer present to be able to fully explain and answer questions about the document being signed. That's already missing. The other issue that you have is this issue of the unintentional, unauthorized practice of law, where again, a paralegal or a non-attorney in your firm may know the answer to a question. And are you providing potential legal advice by answering those questions? And frankly, there's just no one there to verify that that's happening or not. So we're not saying that the lawyer has to be in the meeting the entire time. In Phil's firm, they are, We see a lot of benefit of, sharing with prospective clients that an attorney is going to sign this document with you and be with you the whole way. We have a 2 meeting process, so we're happy to give those clients two 90-minute meetings where they know that all their questions are answered. Because what we find is that those execution meetings, those signing meetings, are the apex of the client's happiness. So it's better for the lawyer to be there. It solidifies the relationship. And then there's just other marketing opportunities that happen at this point, whether it's asking for Google reviews or asking for client referrals or other things that, we also refer to financial advisors. This is a great point to do that. And that's better done by the lawyer. So there's just some other advantages as well, in addition to just liability protection of not having this kind of gray area of a non-attorney doing the signing meeting. And then last, but certainly not least, is kind of this main subject of a debate that happened down in Carlsbad. And it's around this issue of holding family meetings. And I've seen some chatter on LinkedIn about this. I've gone back and forth with a couple of lawyers about this. And it's this idea of holding a meeting after the estate plan's been signed and executed with the whole family. And what lawyers are doing is basically trying to, I see the good intention behind this meeting. I see some pros to it. One of the pros that the lawyers have put forth is that it is better for these conversations to happen with family now, so that there can be a conversation, people aren't left in the dark, and then there isn't this like shock and awe at the point of someone becoming ill, incapacitated, or passing away. And then the family kind of dealing with grief on top of like this potential shock. And I can tell you, I feel like there were a number of points that were made, mostly by attorney Phil Cavish, about the downsides of this meeting that certainly swayed my opinion personally as well, to believing that they're not a good use of time. First of all things aside, they're usually money wasters or losers. For the most part, people aren't charging a higher fee or an additional fee in order to hold this meeting. And so it becomes another third, fourth, fifth meeting that the lawyer is holding with the family. But the major issues that are the liability traps and the potential just bad business decisions that we came up with, and I say we, but Phil did, is around this issue of creating expectations. What's happened, your estate plan, as you know, lawyers, is a snapshot in time. It is how you designed your plan at that given moment. And you and I know that how that plan might actually end up looking at the point of their passing away may be very different. It may be different in terms of the type of assets they have, how much assets they have, their distribution pattern, who's going to be in charge, etc. So why would you hold a meeting with family to talk about how it's set up at one point in time, which is premature, because we don't know that this is in fact going to be the way that the plan's going to be eventually administered come time to settle it. So, I think that's one issue, is it creates an expectation. Someone's like, "Ooh, I get 50% of the estate." And then something happens along the way, 20 years later, your family doesn't like you anymore, and now you're getting nothing, and you're disinherited. Now you feel some sort of way. I was promised 50% of the estate. And, the question could you potentially end up in litigation, potentially around some issue or the state, maybe not you, the firm, right? Also, something Phil said is that now it creates this dynamic where people are viewing their parents, assuming they're children beneficiaries, as dollar signs. Oh, I get to inherit the house that's worth $3 million, and they have this kind of anticipatory expectation. So that's also a bad result. The other main issue that I thought was like the nail in the hammer for me was this issue of possibility of undue influence or coercion that gets created. And what I mean by that is, let's say you now hold this family meeting. Let's say the relationship with one kid isn't great, so you're only giving them like maybe an outright distribution of a flat amount, a gift, or maybe you're giving them a smaller share than their other sibling, right? And so let's say you go into this meeting, you share why this is the case, et cetera, et cetera. And then there's a family discussion around fairness and everything else. And let's just say the child that's getting a lesser share has multiple conversations with mom and dad and says, hey, I really don't like the way you set up this plan. It's not fair. I do this and this and this, and you've taken care of, Kristina's kids during this time, and I haven't had any kids, and da 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 da. And eventually, let's just say the parents go, you know what? He's right. We really need to make this fair. And they go and change the plan. The question that's now left, the gray area that's been created, as a result of this family meeting, have you potentially created undue influence and coercion? Because now you've got a beneficiary that's in the ear of mom and dad that's telling them, I don't like the way this is set up. You should change it. You should change it. You should change it. Maybe they don't even really want to change it, but they just want their kid off their back. And now they just go to you, and maybe they won't go to you because they will be fearful of potential issues. They go to another lawyer and they go and change their plan. So, not a good result, right? And now you've got another kid that was in that meeting that says, hey, when did that change? I thought we were giving, Jason that smaller share or whatever it is, right? I also think the result is certainly unnecessary drama and conflict. I will tell you personally, I was made privy to my mom's estate plan. I wish I wasn't. I find myself unfairly trying to sway her to make changes and do something different because I don't like the way it got set up. And now I dread the idea of having to administer that when that time comes. This idea that the kids need to know now is not it's not a good one. And it's not one that necessarily, it has a lot more downside than it has upside. And so the other issue that comes into play that I think is also a potential issue that you have with these family meetings is around the ability to represent the kids that are in that meeting. And if you now have a conflict of interest, maybe now they want to set up a certain estate plan because they know they're about to inherit 50% of mom and dad's estate and da 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 da. Can you now represent those kids now that they've been privy to, information about another client who's now your other their parent or another client of yours? So just a lot of downsides. So it's something to consider. There was no kind of final end all be all response to the debate, but I think a lot of points were made. And I thought, man, this is going to be a fantastic podcast episode that's going to certainly, hopefully get conversations going, certainly get you considering some other options. And if you are doing more than a 2-meeting process right now, I would definitely consider talking to us about your customer service journey. We can talk to you about streamlining this to make it more efficient, a better use of your time, better for the clients, more streamlined. And take out some of those liability traps that so many lawyers are currently circling. And of course, those liabilities, you may not see them right now in the moment, but when you will see them will be years later when that plan goes to get administered. So that's what I have for you today. Thank you so much for tuning in to today's controversial podcast topic. I'd love to hear what your thoughts are about some of these. So feel free to drop a comment. Feel free to share this episode on LinkedIn or with a colleague. I welcome the feedback and input. I recognize that people have different ways of approaching, but I hope we've given you some food for thought today. So thank you so much. And I look forward to continuing to help you unlock your practice's potential. Goodbye, everybody.